I say Constitution. So, you choose. But let's say there's a search and seizure problem, a Fourth Amendment problem, or maybe the police interrogated my client a little too aggressively and they violated his right to counsel under the Sixth Amendment. Sometimes those things happen. And we're not really saying not guilty forever. We're saying not guilty for now, most of the time, because we're going to review the evidence and see what the case is about. Look, who am I to suggest that the government might actually overcharge somebody with a crime for publicity reasons or for political reasons or because they have egos like the rest of us do? Why would I dare suggest that? Well, because I've lived it for almost 30 years, folks, and this stuff happens. So sometimes we plead not guilty because there's a charge that's too much. And what we're really doing is entering into a phase of negotiation where ultimately it's going to be a guilty plea, maybe to something that's more realistic. I don't know, maybe not. But the point is we have a constitutional right in this country to look at the evidence against us, evaluate the case, and then make informed decisions. In fact, it's really difficult to make any informed decision without doing that. People have heard me say the magic words before. In order to enter a plea in any criminal case, you have to do it knowingly, intelligently, and voluntarily. What does that mean? If you don't have the evidence, if you haven't seen discovery, if you don't know what the case is yet against you completely, not just what it shows on the videotape on TV, but completely, then you're not doing it knowingly, intelligently, and voluntarily. And that's not fair. We don't want a system like that forces people to plead guilty at arraignment to these kind of things. Now, I'm not talking about the speeding tickets because, by the way, speeding tickets, if you sign the waiver on the back, send in your payment. That's a guilty plea.